The Pepsi case was heard before the High Court of Australia in April 2025. While we wait for the final ruling, now is the perfect time to rewind and break it all down. What happened, why it matters, and what it could mean for the future of global tax law. But first up, why should anyone care? Well, this case goes beyond soft drinks. It could redefine how intellectual property is taxed. It raises two major questions. First, can payments without a clear IP clause still include royalties? And second, how will the diverted profits tax apply in real court settings? Even though the dollars at stake, which is about 3.6 million in royalty withholding and 29 million in diverted profits tax, aren't massive compared to other tax battles, the legal precedent is. So, let's unpack it, starting with the key players. We have Pepsi, the global beverage giant, Schweppes Australia, who bottles and sells Pepsi in Australia, CM Singapore, a Pepsi Group company that makes the secret concentrate used in the drinks, and PBS Australia, a Pepsi affiliate nominated to sell the concentrate to Schweppes Australia. Now, back in 2009, Pepsi and its affiliate Stokely Van Camp gave Schweppes Australia exclusive bottling rights for Pepsi, Mountain Dew, and Gatorade. From here on, I'll refer to Pepsi and Stokely Van Camp as just Pepsi because they're part of the same group and they have almost identical facts in this case. Now, the agreement stated that Schweppes had to buy the concentrate from Pepsi or a subsidiary which Pepsi nominates to sell the concentrate. Pepsi nominated its Australian affiliate, PBS Australia. PBS Australia, in turn, sourced the concentrate from CM Singapore, a Singapore affiliate which made the concentrate using a Pepsi-supplied formula. Schweppes Australia would therefore place the purchase with PBS Australia. PBS Australia would take the order and the payment, place the order for concentrate with CM Singapore, and pay CM Singapore the full contract amount, less a margin for itself. But here is the kicker. The agreement made no explicit mention of a royalty payment for using Pepsi's IP, just payments for the concentrate. And that is what sparked the tax dispute. Enter the Australian Tax Office. The ATO argued that the payments for concentrate actually included embedded royalties for the use of Pepsi's branding and IP. Pepsi argued that it was just selling the concentrate. That's it. But the commissioner had another argument. If it's not a royalty, then this is a scheme to avoid tax. And that is where the diverted profits tax comes in. In November 2023, the case hit the federal court, and the judge had three big questions to answer. First, were the payments for IP use, not just for concentrate? Second, did Pepsi actually receive the money in the US? And third, if not royalties, was this a tax avoidance scheme to which the DPT applies? The court said yes to all three questions. On the question of royalties, Justice Moshinsky said it's unrealistic to think Pepsi gave away its valuable brand for free. The IP was essential to the deal, even if it wasn't spelled out in the contract. In his words, the Pepsi brand is one of the strongest and most valuable brands in the global beverage industry. It would be very surprising if Pepsi was prepared to license the relevant trademarks for nothing. The next issue the judge had to determine was whether, despite the payments being made to PBS in Australia, they were actually received by Pepsi in the US. Now, this is important because even if the payments included a royalty, unless the payment was made to a party outside of Australia, there would be no royalty withholding tax obligation. On this issue, the judge determined that while the payments were made to PBS Australia, the party entitled to receive the payments was still Pepsi in the US. And the payments to PBS Australia was simply a direction to Schweppes to pay PBS Australia rather than Pepsi. This meant that the payments belonged to Pepsi in the US because they were dealt with on behalf of Pepsi as they directed. In doing so, the judge ruled that the payments are deemed to have been paid by Schweppes to Pepsi. So the payment was considered a royalty to a foreign entity, triggering the royalty withholding tax. On the question of the diverted profits tax, now is a good time for a brief sidebar to explain what the diverted profits tax is and why it's important to consider despite the fact that the royalty question had already been answered. The DPT is designed to prevent large companies from shifting profits offshore to avoid Australian tax, particularly through artificial arrangements. Broadly, the DPT will apply if a company enters into a scheme that enables it to obtain a tax benefit, and if the scheme was entered into for the purpose of allowing the taxpayer to obtain the tax benefit. If it applies, the DPT imposes a 40% tax rate on diverted profits, which is significantly higher than the standard 30% corporate tax rate. However, if there are commercial reasons for the transaction that are not tax-driven, the DPT will not apply. Now, in deciding whether the DPT does apply, the following questions have to be answered. Firstly, whether Pepsi obtained a tax benefit from this scheme. And secondly, whether Pepsi entered into the scheme for the principal purpose of obtaining the tax benefit. Now, how does a court decide whether a tax benefit was obtained? Essentially, it must ask the question of what would have or could have happened if the scheme was not entered into. Put plainly, would Schweppes have paid a royalty if the scheme didn't exist? The Commission opposed that, if it wasn't for the scheme, the contract might be expected to have said that payments made by Schweppes were for both the concentrate and the license of intellectual property. Justice Muschinsky of the Federal Court accepted this alternative, meaning that the tax benefit was established. The next issue is the question of purpose, so the intent behind entering into the scheme. An important point to note here is that the DPT legislation intentionally lowers the threshold for this test from sole or dominant purpose to principal purpose, or one of the main purposes. This means that if there are numerous reasons for why a company entered into the transaction, it is enough for it to be proven that one of the main reasons was to secure a tax benefit. To this end, the federal court concluded that one of the principal purposes of Pepsi entering into the scheme was in fact to obtain a tax benefit, namely, not paying Australian royalty withholding tax and reducing US tax on their income. The judge concluded that the terms of the bottling agreements were contrived, in that royalty payments were disguised as purely payments for concentrate. So, a double win for the ATO. Following the court win, the Australian government announced new penalties for companies who mislabel or undervalue royalty payments, and the ATO dropped a draft ruling on royalty withholding tax, doubling down on IP-related tax arrangements. Against this backdrop, an appeal was lodged by Pepsi, which was heard by the full federal court in June of 2024. I'll cover this appeal in the next video, but here are some of my final thoughts. Unsurprisingly, this case isn't just about soda. It's about how tax law keeps up with global business and how governments are stepping up to challenge how profits are moved across borders. Whether you're a law student, a tax advisor, or just curious, this case is one to watch. If you enjoyed this video, let me know. And if you'd like to connect on LinkedIn, I'll be posting part 2, so keep an eye out. See you soon.